Good afternoon, everyone, and thank you for joining our first joint webinar on the Every Student Succeeds Act, or ESSA, Foster Care Joint Guidance. Both the Departments of Education and Health and Human Services are pleased with the new ESSA protections for children in foster care and the tremendous positive impact that these new provisions will have on educational outcomes for children in foster care. Providing education stability for this vulnerable population is essential to their success in school and helping them to reach their full academic potential. We know that the true impact of these new foster care protections will happen through effective implementation at the local level, and we look forward to providing opportunities over the next several months to clarify the new ESSA requirements and assist you with getting started on the implementations of the provisions. I'm Mary Mislevich, the Casey Fellow at the Department of Education, and my fellow presenters today include Kelly Fitzpatrick, Policy Advisor from the Office of Planning, Evaluation, and Policy Development at the U.S. Department of Education, Phoebe Steines, Chief Deputy from the Administration on Children, Youth, and Families from the Department of Health and Human Services, and Kathleen McDott, Project Director from the Legal Center for Foster Care and Education at the ABA Center on Children and the Law. So before we begin today, we'd like to find out who is participating on the webinar through a quick poll. So on your screen, you should see 4 choices. Please select which agency that you identify with, and if it's not any of the 4 listed, please click Other. And we're going to give you about 20 seconds to respond to the poll. While we're waiting for the results, I'm going to go over today's agenda. So the webinar will include a brief background on the federal legislation related to school stability, a summary of the ESSA foster care provisions, and an overview of key sections of the guidance. Given the quick timeline to implementation, we are also going to provide you with some tips to get started on implementation and collaboration immediately. There's lots of information from the guidance to cover. This is just the beginning in a series of webinars that we will be offering. And the future webinars will do a deeper dive into the different topic areas and showcase effective examples from your peers in the field. We hope to have time at the end of the presentation for question and answers, but if we're unable to answer all of your questions, then we will use those questions to inform the content of our future webinars. And please go ahead and type the questions that you have throughout the webinars in the question boxes. And it looks like our results are in. All of the attendees today, we have 15% from state education agencies, 24% from local education agencies, or LEAs, 19% from state or tribal child welfare agencies, 16% from local child welfare agencies, and 26% from other. So thank you so much for filling that out. Good to know. So moving on, we're going to begin the webinar with a reminder about the importance of educational stability for children in foster care. Currently, there are about 400,000 children in foster care. Approximately 270,000 of them are school-aged. And when we refer to children in foster care, we are including all children in foster care, including tribal children. Children enter foster care because they've experienced abuse and neglect. Many have been separated from their families and all that is familiar to them. And once in foster care, they often change placements frequently and therefore must transfer schools, where they often encounter delays to enrollment and records transfer. These factors all contribute to the poor educational outcomes that foster youth experience when compared to their peers, such as lower graduation rates, higher rates of chronic absenteeism, grade retention, suspension and expulsions, and also much lower scores on academic assessments. Studies have found a direct link between education stability and improved educational outcomes. Furthermore, a consistent school environment can help to counteract some of the negative effects of foster care. So cross-system collaboration is essential to ensure the educational stability needed to improve these outcomes. Next, I'm going to pass it back to Stevie, who is going to briefly provide us with some background on federal legislation as it relates to foster care.
Thank you, Mary. I'd just like to take a few minutes to discuss Fostering Connections and the Every Student Succeeds Act. So Fostering Connections amended the requirements under Titles 4B and 4E of the Social Security Act, which are two major sources of federal funding for state and tribal child welfare agencies. Fostering Connections requires child welfare agencies to include 3 key assurances in the case plan for each child in foster care. First, that each placement take into account both the appropriateness of the child's current educational set and the placement's proximity to the school the child was enrolled in at the time of placement. Second, that it has coordinated with relevant LEAs to ensure that a child in foster care remains at his or her school of origin if remaining at that school is in the best interest of the child. And third, where remaining in the school of origin is not in the child's best interest, that the child is immediately enrolled in a new school and that his or her educational records are provided to the new school. In short, Fostering Connections provided the first federal requirements for educational and child welfare agencies to work together to ensure the educational stability of children in foster care. Turning now to the educational stability provisions under the Every Student Succeeds Act, which was signed into law on December 10, 2015. ESSA reauthorized and amends the Elementary and Secondary Education Act of 1965, or ESEA. For the purpose of this webinar, ESSA created new foster care provisions under Title I, Part A of ESEA. Title I, Part A sets forth the assessment and accountability requirements for SEAs and LEAs and provides funding to support the education of disadvantaged students across the country. ESSA builds on the legislative successes instituted by Fostering Connections and institutes complementary provisions for educational agencies. Specifically, ESSA requires SEAs and LEAs to collaborate with child welfare agencies to ensure educational stability for children in foster care, including through procedures to address possible needs for transportation. SEAs and LEAs must implement the ESSA educational stability provisions by December 10, 2016. Of note, ESSA also amends the McKinney-Vento Homeless Assistance Act. It removes from the definition of homeless children and youth those children who are awaiting foster care placement. Children who fall under this definition must be served under the McKinney-Vento Act until at least December 10, 2016. After this date, SEAs and LEAs must meet the Title I requirements for all children in foster care, including those awaiting foster care placement. Finally, it's important to note that nothing in ESSA supersedes the agency's obligations under other federal laws, including the Individuals with Disabilities Education Act and Section 504 of the Rehabilitation Act. I will now turn it back over to Mary to go over the joint guidance.
Thank you, Stevie. So with this legislative context in mind, we will now shift to our overview of the ESSA foster care guidance. We will start with reviewing the statutory language for each of the sections and then break down the key points from the guidance. As I mentioned, we don't have time to cover every section of the guidance, but instead we'll focus on the key topic areas and we'll dive more in depth into all of the guidance in future webinars. So hopefully you have all had a chance to read the guidance or review the guidance, which was released last June and was accompanied by 2 Dear Colleague letters. It was the first ESSA guidance package released from the Department of Education, which reflects both the priority of this population and the quick timeline to implementation. The guidance was developed jointly between the Departments of Education and Health and Human Services and solicited input from stakeholders in the field. The guidance provides clarity on the ESSA provisions, and we hope will serve as a tool for collaboration and implementation of the provisions. It also includes examples of promising practices from the field because we know many states have been working on this for a long time and have learned a lot along the way that we would like to share with you. So following the guidance outline, we're going to start with the best interest determination. The ESSA states that SEAs must provide assurances that children in foster care enroll or remain in the school of origin unless there is determination that it is not in his or her best interest to attend the school of origin. The best interest determination must be based on all factors, including appropriateness of the current educational setting and proximity to the school in which the child is enrolled at the time of placement. In the guidance, we break down these provisions to help to clarify them and provide some recommendations on how to go about making this determination. So first, the guidance encourages that the SCAs and the state child welfare agencies establish uniform guidelines for local agencies. Given that LEAs and local child welfare agencies need to work across districts and counties and work with multiple agencies, standardized protocols will help to ensure consistency and avoid any confusions that may happen if different localities are developing separate protocols. In addition, both agencies should consider multiple student-centered factors in addition to those in the statutes. Some of the examples listed in the guidance include child's attachment to the school and relationships with their teachers and their peers, placements of siblings, availability and quality of services, among others. Like fostering connections, the guidance also recommends that transportation costs should not be a factor. The guidance also makes recommendations that the child should be consulted if appropriate, as well as adults who have meaningful relationships with the child. If child welfare agencies and LEAs can't come to an agreement, the guidance recommends that the ultimate decision should reside with the child welfare agencies. If there is disagreement from external parties, then the guidance encourages that SCAs and LEAs coordinate with the child welfare agencies to develop a dispute resolution process. This process should be fair to all of the parties and be reached in an expeditious manner. Finally, to the extent feasible and appropriate, a child must remain in his or her school of origin while awaiting a decision in order to reduce the number of school moves. So I'm going to pass it on to Kelly, who is going to cover transportation and the other ESSA.
Thank you so much, Mary. So we know that in order to maintain some children in foster care in their schools of origin, transportation may sometimes be needed to be provided. The ESSA addresses transportation in a couple of important ways. Under the ESSA, LEAs must assure that they will collaborate with state or local child welfare agencies to develop and implement, by December 10th, clear written procedures for how transportation will be provided, arranged, and funded for the duration of a child's time in foster care. These jointly developed procedures must ensure that children in foster care will promptly receive transportation in a cost-effective manner consistent with the Fostering Connections Act. If there are additional costs for providing transportation to maintain a child in foster care in his or her school of origin, LEAs will provide this transportation if the local child welfare agency agrees to reimburse the LEA agrees to pay for these additional costs, or the LEA and local child welfare agency agree to share the cost. The guidance further clarifies some of these requirements. It clarifies that in order to meet the requirement that transportation be provided in a cost-effective manner, LEAs and child welfare agencies should explore low-cost and no-cost options for providing transportation, such as by utilizing public transportation or existing bus routes that are used for other students. The guidance also makes it clear that even if an LEA doesn't transport other students, it must still ensure that children in foster care promptly receive transportation consistent with the procedures it develops with child welfare agencies. It's important to note that transportation to maintain children in foster care in their schools of origin is an allowable use of Title IV-E funds under the Social Security Act, as well as funds provided under Title I Part A of the Elementary and Secondary Education Act. We strongly encourage LEAs and state or local child welfare agencies to maximize all of these potential funding sources to ensure that the costs for transportation are not too burdensome on any one agency. The guidance emphasizes that LEAs and child welfare agencies should work together to reach agreement as to how transportation is funded, and collaboration is required. These transportation procedures should include a state or local dispute resolution process to address cases when parties cannot come to agreement over how transportation costs will be provided. The guidance recommends that SCAs and state child welfare agencies also develop uniform statewide guidelines and procedures. This is a really important role that states may play that will help ensure consistency across district lines. This is critical because we know that children in foster care are highly mobile, so this consistency will help ensure successful implementation. Finally, the guidance makes it clear that a child must remain in his or her school of origin while any disputes regarding transportation costs are being resolved. In some cases, it may be in the best interest of a child in foster care to move to a new school rather than staying in his or her school of origin. The ESSA lays out some new requirements regarding this issue. Under the ESSA, SEAs must provide assurances that if it's not in a child's best interest to stay in his or her school of origin, that child must be immediately enrolled in a new school, even if the child is unable to produce the records normally required for enrollment, such as residency records or immunization forms. The enrolling school must then immediately contact the school the child last attended in order to obtain the relevant academic and other records. The guidance clarifies a few important points about immediate enrollment. First, no child in foster care can be denied enrollment because they don't have proper documentation. Second, it clarifies that enrollment is not just enough. Children in foster care should also be attending classes and receiving the appropriate academic services that they need to succeed. Lastly, SEAs and LEAs should review their policies and procedures to make sure that they are removing any barriers that children in foster care are facing to immediate enrollment. We know that it will be critical to have staff at the state and local level, both on the education and the child welfare side, in order to ensure successful implementation of these new foster care provisions under the ESSA. The ESSA addresses this need by requiring points of contact at the SEA and LEA levels. SEAs must provide an assurance that they will designate a point of contact for their child welfare agencies. And the statute also clarifies that this point of contact cannot be the McKinney-Vento State Coordinator for Homeless Children and Youth. At the LEA level, LEAs must provide an assurance that they will designate a point of contact for the corresponding child welfare agency if the child welfare agency notifies that LEA in writing that it has designated a point of contact. The guidance expands on these new requirements by providing some recommendations regarding timing and the roles and responsibilities of these points of contact. On the SEA point of contact, the guidance clarifies that this person should be designated as soon as possible, given the quick statutory timeline for implementation. Additionally, SEA point of contact responsibilities should include monitoring LEAs and coordinating with the state child welfare agency to issue state guidelines around the new requirements. At the LEA level, this LEA point of contact should also be designated as soon as possible, even if the local child welfare agencies have not yet notified LEAs in writing. The responsibilities of the point of contact should include coordinating with local child welfare agencies to develop a process for implementing the new provisions. On both the SEA and LEA side, the guidance strongly emphasizes that these points of contact should have the capacity and the resources so that they can successfully guide the implementation of the new provisions. Next, I'm going to turn it over back to Stevie to address child welfare points of contact. Stevie?
Thank you, Kelly. So first, it's important to note that neither ESSA nor Fostering Connections require child welfare agencies to establish points of contact. That being said, we strongly encourage state, tribal, and local child welfare agencies to designate points of contact as soon as possible. That is because child welfare points of contact will play an instrumental role in working with the state and local education points of contact to develop processes and procedures to ensure effective implementation of the educational stability provisions of ESSA. Child welfare points of contact will serve as the primary liaison between schools, families, and other service providers. And as Kelly mentioned, an LEA is only required to designate a point of contact if it has been notified in writing that the corresponding child welfare agency has designated a point of contact. To that end, we have provided a template letter in the joint guidance that child welfare agencies may use to provide sufficient written notice to LEAs of a point of contact designation. I now want to turn to the topic of collaboration. Both Fostering Connections and ESSA encourage and at times require collaboration between child welfare and educational agencies. Given that they serve the same children, child welfare and educational agencies should work together to remove barriers that may hinder the implementation of these educational stability provisions. This collaboration must happen at both the state and local levels and is needed across district, region, and state lines. We also encourage agencies to explore opportunities for cross-training staff on the need for educational stability and the unique challenges facing youth in foster care. And as you well know, data and information sharing is a critical component of successful collaboration. To that end, we encourage both agencies to consider the passage of ESSA as an opportunity to build their data collection and sharing capacities. With that, we have concluded our overview of the Ed-HHS joint guidance. Everything that Mary, Kelly, and I have covered thus far today is spelled out in much more detail in the guidance itself, a link for which is on this slide. The guidance also includes spotlights from the field, which share promising practices from agencies across the country. We hope these spotlights will prove helpful to you as you move toward full implementation over the next few months. I now want to turn it over to Kathleen McNaught with the ABA Center on Children and the Law and the Legal Center for Foster Care and Education, who will walk us through both lessons learned from the field and how these lessons can be scaled up to guide broader implementation across the country.
Thank you so much, Stevie, and thank you for inviting me to participate in this webinar. As Stevie mentioned, I am with the American Bar Association Center on Children and the Law and have been with the ABA for the last close to 15 years. For almost 10 of those years, I've had the pleasure to lead a project known as the Legal Center for Foster Care and Education, which is a project focusing on providing expertise and technical assistance on legal and policy matters affecting the education of children in care. It's a three-organization collaborative, and I work closely with our partner organizations, the Juvenile Law Center and the Educational Law Center, to provide this support. We also promote promising practices and reforms that support education of children in foster care and work in dozens of states to provide that support and to address a range of educational related issues. Certainly the passage of ESSA and these changes, current changes that are taking place at the federal level, have been a big focus of our work in the last few months. And so I really do encourage folks who are looking for additional tools beyond the federal tools that were mentioned here to feel free to visit our website. We have Q&As and a 5-page summary of the guidance that we've put together through the resources we have there at the website you see on the slide. So what have we learned in this close to 10 years of working with states and local jurisdictions on issues of foster care and education? I think there are some pretty broad themes that certainly emerge that align really well with the provisions you just heard addressed in the law, as well as the additional detail that's been provided in this joint guidance. And I think that first big theme is that interagency collaboration is critical. And so for the years both pre and post the passage of Fostering Connections, there were many jurisdictions, both at the state and local level, doing some really good interagency collaborative work, where folks from education agencies and child welfare agencies, as well as other key stakeholders, representatives from the courts, from the legal advocacy community, collaborations that include parent and child voice, caretakers, all working together to address barriers and to identify policies and practices that support kids in foster care. It's in those jurisdictions, and some of you may be the ones who are on this call, where good work has already begun prior to the passage of this law. I think those become the examples that we can learn from for other places where this interagency collaboration has not been as robust. The other lesson we've learned is that it's in those state and local collaborations when there are designated staff resources that are working to address the communication across agency is where we see success and good collaboration. And that's true when we have designated staff or points of contact, as the new law is calling those identified folks, both on the child welfare side as well as on the education side. And that's true both at the state and local level. When there are people who understand the other system, are able to navigate across system and serve the needs of kids in foster care, we see success. Another lesson is data collection and information sharing, the importance of doing that and how critical it is to drive reform and change. While we do see an increasing number of states and local jurisdictions who have the capacity to share information across child welfare and education, we know that there is much more needed in this area and much more sharing of information that needs to take place to truly see success. The jurisdictions that were able to identify their data outcomes for kids in care and use them to identify their strategies, those are the ones that you're going to see have really made gains over the last 10 years. Investing in students in foster care improves strategies for all students. And I think this is something we see time and time again when there is attention and resources paid to this specific group of vulnerable students. The strategies, the interventions, the policies that are put in place to benefit those youth are really policies and practices that can benefit many students in a particular school or district. And so the strategies that we're realizing for children in foster care can really be brought into many other vulnerable student groups. Finally, I think another key lesson that we've seen around the country is the role of courts and judicial leadership and how important that can be to improving education outcomes. When we see our courts and our legal systems asking education-related questions, monitoring the educational stability and success of youth when their cases are before the court, that piece is critical, as well as seeing our judicial leaders who are helping in system reform efforts, both at the state and local level, helping to bring agencies together, helping to facilitate dialogue and support the collaboration that needs to happen across agencies to see success. So for states and jurisdictions we're currently working with, there are a few things that we're really emphasizing need to happen now, and I thought it would be helpful to share that on this webinar. Number one, we need to raise the visibility of these new ESSA provisions, both the statutory provisions as well as this detailed joint agency guidance. For those of you who work with child welfare agencies, changes to federal education law may not be readily apparent or identified quickly as an area for folks to pay attention to. So drawing child welfare agencies' attention to changes in this education law is going to be key. For those of you on the phone who are working in education agencies, the broad changes that come with the ESSA reauthorization, there are many, many areas where state and local education agencies are going to be focused. And it's going to be important to make sure that these particular provisions related to foster care rise to the level of a priority when it comes to implementing the new provisions. I do think the other thing we have been sharing is the importance of creating a sense of urgency. That December 2016 timeline, some of the quickest timelines in all of the ESSA implementation pieces, really stress that these foster care pieces need attention, and they need attention now. We also, and I think this was echoed in the prior speakers, the encouragement for the quick identification of those points of contact at both the state and local level and in both child welfare and education. Getting those people in place is going to be a key first step in being able to move forward with the other work that needs to be done. At the state level, it's clear that from the guidance that states are being strongly encouraged to develop the protocols and the guidance to share with other local jurisdictions, and the development of that guidance really needs to be expedited in order to provide the support to the local jurisdictions who are going to then be working on their planning. So things like best interest decisions, how to address cross-jurisdictional issues, all of these need to be addressed through that state guidance and support. At the local level, discussions hopefully have already begun in your jurisdictions, but if they don't, they need to begin now about those written procedures that need to be documented and finalized by December of 2016. And I think finally, and maybe most importantly, everyone needs to think about what other help they need to really be successful in implementing these new provisions that are really designed to see educational stability and success for kids in foster care. So what other help is needed, that needs to be communicated. So for local practitioners to share that with your state leadership, and for state leadership to be sharing it with the federal level, to be sure that everyone knows what the challenges are for implementation. I'm going to turn it back over to Mary.
Great. Thanks so much, Kathy. And that is a perfect segue into our next section on technical assistance. So before I talk about the different technical assistant opportunities that we will be offering, we have another poll that we would like for you to fill out. And your input will help us as we plan our future TA or technical assistance opportunities. We're just waiting for the poll to come up. Oh, here we go. I'll give you a few more seconds. All right, so it looks like, not surprisingly, transportation is number one at 60%, state and local points of contacts at 46%, immediate enrollment and records transfer at 32%, and dispute resolution and best interest determination tied at 31%. So thanks very much for that, and we will definitely be using that as we plan our future learning opportunities. So as of today, we are planning a series of webinars over the next month or so that will do a deeper dive into the different guidance topic areas and spotlight promising practices, as Stevie mentioned earlier. We are planning on having those on these webinars on Wednesdays from 2 to 3 Eastern Standard Time. So go ahead and mark that on your calendars, and we'll share with you any updated information as we receive it. In the meantime, if you have any questions regarding the ESSA requirements, please don't hesitate to get in touch with us. For Department of Ed, you can send questions to the Department of Ed's ESSA mailbox at essa.questions@ed.gov, and we will respond to you as soon as we can. For child welfare agencies, please go ahead and reach out to your Center for State Liaison for any questions that you have, and they will get back to you as soon as possible. And, again, we will continue to look at your questions, and that will help us to inform, any future TA opportunities that we can provide. So that ends the formal part of the webinar, and so we're going to turn to, thank you to those of you that have sent questions in. We're going to turn to those now, and again, you can continue to send in your questions. If we can't get to them today, then we will respond to them as we can. So I'm going to turn it over to Brian, who's going to go through and start off with the question.
Great, thanks, Mary. So the first question is, does ESSA replace the Fostering Connections Act?
That's a great question. Thanks, Brian. So no, the answer is no. ESSA does not replace the Fostering Connections Act. As we sort of talked about a little bit today, the Every Student Succeeds Act simply complements and builds upon the educational stabilities in the Fostering Connections Act, but both acts still stand and are still required.
Great. The next question is, can a child in care continue to have stability if he school stability if he or she achieves permanence in the middle of the school year?
And I'll take that one. Thanks. That is another great question, and we do address this in the guidance. So the statute says that the SEAs and LEAs must collaborate to ensure that a child in foster care remains in his or her school of origin during the duration of the child's time in foster care. Our guidance strongly encourages that once a child has exited foster care, that the agencies still work together to ensure school stability for the rest of the school year if it is best for the child. We know that transitioning out of foster care can be a very difficult time for a child, and that a supportive, consistent school environment can ease this transition. So, if possible and if appropriate, we encourage that agencies work together on a case-by-case basis to figure this out.
Great. The next question is, who is considered a child in foster care for the purposes of these provisions?
I can take this one.
Sure.
So that also is addressed in the guidance. So our definition of children in foster care is consistent with Fostering Connections Act. It's child in foster care, which is 24-hour substitute care for children placed away from their parents or guardians, and for whom the Child Welfare Agency has placement and care responsibility. So this includes, but is not limited to, placements in foster family homes, foster homes of relatives, group homes, emergency shelters, residential facilities, child care institutions, and pre-adoptive homes. A child in foster care in accordance with this a child is in foster care in accordance with this definition, regardless of whether the foster care facility is licensed and payments are made by the state, tribal or local agency for care of the child, whether adoption subsidy payments are being made prior to the finalization of an adoption, or whether there is a federal matching of any payments that are made. A long answer.
Are preschool-aged children in foster care affected by these provisions?
A great question. For the person who's asking, I'd refer you to question 7 in the joint guidance. And the answer to that question says, if an LEA offers a public preschool education, then an LEA must also meet the Title I requirements for children in foster care. And that includes ensuring that the child in foster care remains in his or her preschool of origin unless a determination is made that it's not in the child's best interest. And that would also apply to transportation if it's needed to keep that child in his or her school of origin.
And we have a few more questions coming in. This is Liz Lovner with the Children's Bureau Policy Division. One of the questions is about transportation costs under Title IV-E, and if that's only for youth who are, or children who are Title IV-E eligible. And the answer to that is yes, it is only for those children and youth who are Title IV-E eligible, who are receiving it can be a part of the Title IV-E foster care maintenance payment. It may be, but it's not required to be part of that payment. And child welfare agencies can also claim Title IV-E administrative costs, but again, that's only going to be for those Title IV-E eligible children.
Sure. Another question that we received is about the points of contact. The question asks, can the LEA point of contact be the local McKinney-Vento liaison? So unlike the SEA point of contact, in which the statute is very clear that that cannot be the state coordinator for homeless children and youth, the statute is silent as to whether or not the LEA point of contact could also be the local liaison. And the guidance also does not address this specifically. However, I would say the guidance does strongly recommend that FEAs and LEAs ensure that their points of contact have the capacity and the resources in order to meet the requirements as an LEA point of contact. So if a local McKinney-Vento liaison already has a lot to do in meeting the requirements under McKinney-Vento, then it probably wouldn't be a good idea to also have that person be the LEA point of contact. At the same time, we know that local McKinney-Vento liaisons are also sometimes very knowledgeable about serving children in foster care. So we would recommend that you consider capacity and resources when determining whether or not the liaison could also be the foster care point of contact.
We also have received a question asking, are there any frameworks that will help guide practice currently available?
And I wanted to draw folks' attention to a framework that our Legal Center project has created known as the Blueprint for Change. So it can be found on our website, the www.fostercareandeducation.org. But it is a framework that outlines the scope of what children in foster care need to be educationally successful. It identifies 8 leading goals and 56 accompanying benchmarks of what you want to achieve for a youth when they're in care in terms of their educational experience. It goes beyond school stability to really all aspects of success. It talks about young kids as well as older kids, so it is a complete framework, and it's a tool we've used in our technical assistance. Some jurisdictions use it as a guide in their direct advocacy work, so I really encourage you to take a look at that if you're looking for a framework to help guide your work. And I would say, the department and both departments are definitely going to be looking at your questions and thinking about whether there are other tools or technical assistance documents that we can provide to help build off of the technical assistance we're providing today. So if you have thoughts about, what format and what content would be most helpful, we'd strongly encourage you to send those in over email at the addresses that Mary discussed earlier. Another question that we received was about what should an LEA do if the local child welfare agency has not yet sent point of contact info in writing. As we said in the guidance, we would strongly encourage LEAs to designate a point of contact, even if they haven't yet heard from the child welfare POC. And this is super important because we know these provisions must be effective by December 10th, 2016, and not just developed, but fully implemented by that date. And so we strongly encourage that LEA to still designate a point of contact as soon as possible so as to ensure effective implementation.
You're just waiting to see if we have any more questions to answer. Hold on 1 minute.
We received a question asking, how do you know if a child is Title IV eligible? I'm not sure who that's from. If it's from from someone on the education side, obviously you would talk to your child welfare agency contact to find out that information. Title IV eligibility is based in several things that have to do with the income of the family they were removed from, and how they were removed, and certain protections that apply under the law. If you're more interested in what exactly Title IV foster care eligibility is, I'd encourage you to go to the Children's Bureau website and get some more information on that. But your child welfare colleague should be well-versed or be able to connect you with someone who's well-versed in exactly what that eligibility would be. And if they are in foster care, they will definitely know that information. It really just depends on the specific circumstances of the child and where they were and the family they were removed from.
Okay, so there's another question about if there are transportation disputes. And if you look at question 28 from the guidance talks about how, we recognize that there are occasions when the LEA and the local child welfare agency may face difficulties in reaching agreement on how to fund additional costs incurred to provide transportation. So the guidance recommends that if the agencies can't come to an agreement, that they provide and develop a local dispute resolution process that the agencies would follow in the event of such disagreements. And also, again, we encourage that the SEA and the child welfare agencies develop a uniform state process for resolving such disputes as part of its overall duties to ensure educational stability.
And just one thing to flag on the transportation dispute issue, there is the Department of Education did release a notice of proposed rulemaking in NPRM on Title I Part A on the accountability data and state plan section of Title I Part A on May 31st, 2016. Because some of the foster care provisions are in this particular section of Title I Part A, this transportation issue is addressed in part in that NPRM, and so we would strongly encourage you to take a look at the NPRM, go to regulations.gov, and please submit public comments if you have any. Those public comments will be used to develop a final rule later this year.
Yeah, so we have another question about awaiting foster care being deleted from the McKinney-Vento Act. So are those children now considered part of foster care even when awaiting foster care placement?
Yes, so the guidance addresses this in a question as well. So as we mentioned, on December 10th, 2016, awaiting foster care will no longer be part of the definition of a homeless child or youth under McKinney-Vento. For states that are not covered states, for covered states, this change does not take effect until December 10th, 2017. So on December 10th, that's when children who are awaiting foster care placement would then need to be served under the Title I foster care provisions. But until December 10th, children who are awaiting foster care placement should still be served under McKinney-Vento. So we would want to make sure that even at the beginning of the school year, as we're starting to transition, that switch does not happen until December 10th. And just wanted to flag that the department today just released guidance on the McKinney-Vento Act as amended by the Every Student Succeeds Act. So if you have more questions on McKinney-Vento, we strongly recommend that you take a look at that guidance. We got one question about whether or not the final guidance will be out by August 31st, which is when we're doing the webinar on transportation. We just wanted to clarify that this guidance, the ED Joint HHS guidance on the foster care provisions, is final, and the portion that addresses transportation disputes is final. If you look at question 28 of the guidance, there's a footnote 31, that says, please note that this question may be revised following the 2016-17 school year pending review of public comment and final rulemaking on proposed regulations regarding the transportation of children in foster care. So what this footnote means is that question 28 and the rules and recommendations that are listed in there are final through the 2016-17 school year. If the proposed regulations address this in any different way, then that would not take effect until the 2017-18 school year. So we definitely want you to refer to the foster care guidance as your main tool to implement these provisions this school year. We received a question about whether the FERPA, which is the Family and Educational Rights and Privacy Act, could be more specific regarding the information that can be shared between education and child welfare agency providers, and that some people have reservations sharing this kind of information, and whether we've been thinking about developing ways to share information. So the foster care guidance does address this in part. There's a short section on data sharing, and we try to provide some recommendations as to what kind of data, in addition to whether a child is in foster care, might make sense for agencies to share with one another. So I'd refer you to that question. Additionally, following the passage of the Uninterrupted Scholars Act, the Department of Education did provide guidance on FERPA and the USA amendments to FERPA. There are links to that in the foster care guidance, and we'd recommend that you take a look at those. Additionally, we are working on new guidance on data sharing and FERPA to come later this year. So we hope to address some of those questions in that new guidance.
So we are about to wrap up the webinar. I know there are a lot more questions, and questions will be coming as people, dive more into the guidance. Again, we will be taking all of these questions into account as we inform our future webinars, and we will make sure to answer your questions as well as we can. So please continue to share those with us. So we just want to say thank you so much for joining us today, and thank you to all of our presenters, both from the Departments of Health and Human Services and Departments of Education and Legal Center for Foster Care and Education. And we look forward to partnering with you in the future. So thank you very much for joining, and have a wonderful afternoon.